Good afternoon. Thank you for joining our webinar today. Our topic, Big Discussions 2022 Employment Law Update. Today's presentation is geared toward public entity employers. If you're here for private employers, please refer to our website. We will have the recording up from Tuesday's presentation by the beginning of next week. A couple of housekeeping items for today. We are in Zoom webinar format. Therefore, our attendees are muted and your cameras are turned off. Should you have a question for our presenters, please use the Q&A button located in your black menu bar. And if you have any technical questions or any other questions outside of that, feel free to use the chat and I can respond to you there. Another feature we're using today is we're utilizing closed captions. There is a button also located in your black menu bar if you wish to turn that off on your end. And without further ado, I will pass this on to Arlene Yang to get us started.
Great, thanks, Stephanie. Hi, everyone. It is a very interesting time to be looking at employment law right now with the tremendous surge in COVID cases and all of the changes from the courts and the regulatory agencies. It's really been a challenge. We know it's really been a challenge for employers to keep track of what they're supposed to do to comply with laws and keep their employees safe. So we are here today to kind of give you an update about what's been going on lately. There's been a lot of changes within the last month and things are just changing hourly, it seems. My name is Arlene Yang. I'm a principal at Myers-Nave and I am I'm based in the San Diego office, but I help employers all around the state. And I focus on advice and counsel for employers, conducting internal investigations, and defending employers in litigation. And I have with us two fabulous attorneys from Myers-Nave as well. We have David Middleton. If you can introduce yourself.
Hi, thank you, Arlene. My name is David Middleton. I'm also based in the San Diego office. My practice includes primarily litigation, workplace investigations, and some advice and counsel to our private and both public employers. And then I will pass it over to Angelica to introduce herself.
Thanks, David. My name is Angelica Pimenito. I'm an associate based in the Oakland office. My practice includes providing advice and counsel to public and private employers, conducting internal investigations, as well as litigation.
Great, thank you. So as we are lawyers, I wanted to just give you the little admonition that this is just to provide you with legal information and it's not intended to be legal advice on any of your particular problems. So we encourage you to contact counsel for individual issues. We are happy to answer questions though as they come up. And I just did want to note that things are changing really rapidly. Actually, as we were just logging on for this webinar, we saw that the Supreme Court has issued a temporary stay related to they just heard two cases regarding vaccine mandates and they just issued opinions. So things are still happening quite quickly. And so today's January 13th, 2022, but in a couple of weeks, things may change. If we can go on to the next slide. Just to give you a preview of what we're going to be talking about today, we're going to be focusing a good bit of this presentation on the COVID-19 health and safety measures. Also talking about SB 16 related to the release of peace officer records, kind of looking at discrimination and social impact updates that you need to be aware of. Also looking at compensation and wage and hour issues, and also leave benefits and accommodations. And we'll also leave some time at the end for any questions. And so then we're just turning to our topic, the first topic of COVID-19 health and safety. This has been a really interesting time in the pandemic in terms of looking at employment law issues. It feels a little bit like back earlier in the beginning of the pandemic when there were changes coming almost daily. Right now we see the New York Times has reported that confirmed virus cases have shot up nearly 600% in 2 weeks in California. And current daily hospitalizations were almost 12,000 related to COVID in California. And there are projections that it could peak at over 30,000 and by the end of January. So, this is causing tremendous staffing shortages for many employers around the state. And, you know, we've heard it with the airlines, and restaurants, and of course the hospitals as well. But every business has been impacted by the large number of employees who are either being required to quarantine or isolate. And then on top of that, the rules on how long they have to quarantine or isolate are also changing. So to get us going with that, we're going to have David.
Thank you, Arlene. As she mentioned, COVID-19 is definitely here with us right now, and we still need to remain vigilant. The New York Times puts out daily confirmed cases. Right now in California, we're above 6.5 million cases with over 100,000 confirmed reported cases yesterday, and we're sitting right now at a 7-day average of about 62,000 confirmed cases every day. So for employers, we really need to remain vigilant in our implementation of policies and procedures in order to have our COVID-19 prevention plans. Next slide, please. As we know, on December 16th, Cal OSHA readopted and revised its emergency temporary standards as it pertains to COVID-19, and those will go into effect tomorrow. So this applies to generally all employers here in the state of California under the California State Plan. So there will be some change and re-emphasis of standards under the revised proposal. Next slide, please. So one of those big changes is that employers will now be required to make COVID-19 testing available at no cost during paid time to employees who were even fully vaccinated if they were in fact coming into close contact with a COVID-19 case. This obligation still remains even if that person is asymptomatic. One of the questions that we get as a labor and employment attorney these days, you get questions all the time. One of the big questions I hear is, what does paid time mean? Now, paid time means that an employer does need to pay for travel and testing expenses. However, the employer is not obligated to provide testing during normal working hours, but you need to operate with the philosophy that your employee should not incur any cost in taking those tests. Now, the revisions also refine what COVID-19 testing means. No longer will be the days of self-testing at home and self-reporting. An employer or a telehealth professional will need to observe the testing results. So you do need to start to put into place recordation and retention policies to keep a record of the testing that your employees are doing. The big question right now, we see a lot, there's a glut in finding testing. So where can employers go to find tests? The California Department of Public Health and the National Association of County and Health Officials website lists different local health departments in your areas where you can get your employees tested. A lot of those health departments, you can look on their website, you can search testing sites by location. And just recently on January 8th, 2022, Governor Newsom signed in an emergency response package for COVID-19 of about $2.7 billion, half of which will go towards increasing testing capacity, accelerating vaccination efforts, and expanding hours for those testing sites in your specific areas. So I would encourage you to remain cognizant of what your local health jurisdictions and local testing sites are doing. Now, what has not changed? Towards the next slide, please. Now, employers must continue to notify their employees, employee representatives, independent contractors, and other workers on their website, at their work site, of possible COVID-19 exposures within 1 day. Now, this notification will take the form of the normal course of action you take when communicating with your employees. That could be personal service, could be email, text message, but you do need to keep a record of who's going to be at your work site each day, possibly implementing a daily survey of individuals who come on your work site, of their name, their contact information, whether they have any reason to believe that they were exposed to COVID-19 before they were at your work site that day. So in case someone does test positive for COVID-19, you have a record of who may be in that exposed group on your work site for the specific day. Also, the revised ETS does require you to notify your employees of the disinfecting plan that you're going to have for their work site.
David, we're getting some questions about whether when the employer is required to provide testing for their employees, is that only if they've been exposed at work, or is it if for any reason that they need?
Now this obligation only triggers if your employee was exposed at the workplace. However, it is the employer's obligation to prove that it's more likely than not that the employee was not exposed to COVID-19 at the workplace. The ETS does lay out guidance that could be a high burden, because you have to pretty much initiate an investigation to prove that your employee was not exposed to COVID-19 at the workplace. So it may be better course of action and more cost effective for you to incur that cost to have your employee tested than initiate an entire investigation just to not have to pay for one employee's test. And thank you for that question, Arlene. If you see anything else and I'm running through, please stop me.
Yeah, so I guess there are also, I mean, I think this has been in the rule for a little while, but we have a question about what it means to have an outbreak.
Yeah, so an outbreak is defined by the ETS as 3 positive tests within the exposed group within a 14-day period. So if you have a person at your work site who tests positive, and the people who are in the exposed group or during the high exposure period, these people who have spent cumulative 15 minutes or more within 24 hours with around that person or that case, and you find that 2 others do test positive within a 14-day period, that would be defined as an outbreak at your work site. Our takeaway as it pertains to the notifications at the workplace is to, like I said earlier, implement a daily attendance COVID survey. A lot of employers you can do this through SurveyMonkey, and keep a record of who's on your site each day. You could even break it down granularly, as if you have multiple locations on a work site, which buildings each person is working in. So you understand if someone has a positive case in one building, it's more likely than not that you really need to get in contact with people in that building. But everyone at the work site, whether they're your employee, employee representative, or independent contractor otherwise, needs to be notified. So you do need to keep record of that. Another big change, next slide, I'm sorry. Another big change is that employees who are exempted from wearing face masks, masking has been in the news pretty much every day. There's new guidance about masking, but those who are exempted from wearing masks in the workplace due to medical reasons, a disability, or other non-restrictive alternative must maintain social distancing of 6 feet, and they must be tested weekly. This also falls under the obligation of the employer to pick up costs for that testing. So these employees who are exempted and need to test weekly the employer will need to cover the cost of testing for those individuals. Now, employers can have policies that are stricter than the ETS. So if you feel like, if you're not going to wear a mask at work and you need to stay home, that's fine. Employers are allowed to have those strict policies. You do need to maintain records in this instance of those employees, their vaccination status. Those who are exempted, you need to have record of that. You need to keep record of the days they're testing each week and the results of those tests. Also, employers are under the obligation to make sure their employees are properly informed and trained on COVID-19 and their prevention plan. So you need to post signage emphasizing social distancing and encourage vaccination and boosters. Encourage your employees, if they can work from home. Remote employees do not fall under the ETS, so that may help. So encourage your employees, to the extent they can work from home, to set up those arrangements to be most effective for your workplace. We do recommend having a written policy that lays out possible discipline for employees who fail to comply with a mask wearing policy. And employees need to be informed that they could be subject to disciplinary action if they fail to want to comply with face masking. Next slide.
Before we go on, I wanted to also, there was a question just to back up a little bit about the when you have outbreak notification or just notification of a close contact, whether an employee's union representative needs to be notified.
Yeah, the employee representative, if they are a union employee, should be notified. I would believe that they're a employee representative. However, I can do further looking into that. And if you all want to be contacted, there will be a survey after the webinar today, and then I can follow up with that information for you all.
Right.
So next slide. This is one of the biggest changes that we see, and every day is changing. The revisions to the ETS had a longer return to work criteria than the California Department of Health, which follows the guidance from the CDC. So the ETS has adopted, as of January 6th, the isolation and quarantine policies from the California Department of Health. And if the California Department of Health changes their policies, those will automatically be adopted into the ETS going forward. So I've heard this saying a lot, that the pandemic is the pandemic of the unvaccinated, and it seems like the guidance and the updated guidance we see from the CDPH and the ETS treats it as such as it pertains to isolation and quarantine. Under these policies, those who test positive for COVID-19 will have to be isolated for 5 to 10 days, depending on certain circumstances. The isolation period could end after 5 days if there are no symptoms present and the negative test is collected on or after day number 5. Now, those in your workplace, the CDPH guidance does lay out specific guides for that as it pertains to those who are vaccinated and booster eligible, but not yet boosted. Now, these asymptomatic employees, emphasis on asymptomatic, are not required to stay home. What they need to do is have a COVID-19 diagnostic test obtained between 3 to 5 days after the last exposure. So this is another emphasis on why you need to have your notifications go out as soon as possible within that 1 day. They need to wear a mask in the workplace, and under the ETS, the CDPH guidance on masking that's in place until February 15th is applied, and it's on the employer to make sure to provide masks if needed, and emphasize that masks need to be worn in the workplace if they're indoors. And then the employee needs to continue to not show symptoms. If an employee, no matter the vaccination status, shows symptoms, they need to go home and they need to test. With that, when you're sending an employee home, we would encourage you to have a policy in place where employees can monitor their symptoms at home, whether that be asking your employees to test their temperature twice a day to make sure there's no fever symptoms coming on, or to just be mindful and monitor any other symptoms that are related to COVID-19 that may show that they've been exposed. Now, we got this question in our earlier webinar, and I want to just address it before we possibly have the question here. If an employee is excluded from the workplace and for a workplace exposure under the ETS, is the employee eligible for exclusion pay? Yes, under the ETS, that the employee that's excluded from the workplace, and this needs to be as a result of a workplace COVID-19 exposure, should receive exclusion pay. Granted that employee was not assigned to do teleworking, and they're not receiving any other disabilities. And so the follow-up question we usually get, how long do I have to pay this? So An employee will typically receive exclusion pay up to 10 days. However, collective bargaining, if you all collectively bargain an agreement for other types of disability pay, or if they're eligible for other disability pay, that may trigger if the isolation period or quarantine period exceeds that exclusionary 10-day period. Employers are prohibited from requiring employees to use California paid sick leave though. Another question we get commonly in this space are, what is the obligation of the local health jurisdictions if they come in conflict with the ETS guidelines or the CDPH recommendations? We've seen actually that the local health jurisdictions, even to the extent that they're stricter than the ETS or the CDPH guidelines, will control. I know some remember that when the indoor masking mandate was put into place, initially, the CDPH came out with clarifying guidelines saying that if a local health jurisdiction had a masking policy before the CDPH provided its guidance, that would control. And that's still the case. On January 6th, the CDPH instructed that California health officers will have legal authority to order isolation and quarantine, and that we encourage you to meet with your Myers-Nave counsel to get clarity if there's any confusion about which controls local health jurisdictions or the CDPH. Next slide. Yeah, so all of this to say that Cal OSHA does apply to public employers, so you need to review your COVID-19 prevention plans and ensure that you're in compliance as these temporary standards do go into place tomorrow. Next slide.
Oh, so we have a number of questions. I thought maybe I could jump in here.
Sure.
One is a question regarding home tests. And the question is whether it can be administered and checked by supervisors? Does it have to be a PCR test administered by medical personnel? What does the ETS say?
Yes, so the ETS actually yesterday, as Arlene referred, this all changed yesterday. Under the CDPH guidelines, yesterday it said that antigen tests were preferred. However, that guidance was removed as of yesterday. So home tests will be acceptable. However, under the ETS, you as the employer or a telehealth professional needs to observe the results. So no longer are the days where the employee can self-test and just tell you they were negative. You need to see it. So you need to make sure you have someone in place, or you can assign someone to say, hey, you're going to follow up with the employees about the results of the testing. You need to observe that. But a home test is fine. There is no specific preferred method of testing that's laid out in the guidelines anymore.
We have some questions about exclusion pay and pay related to people who are homesick with COVID. I think you've covered some of that, and we're going to cover some of that coming up as well.
Yeah, I don't want to touch too much on what Angelica has, but I can speak to the exclusion pay became a part of the ETS last year in June. So in the revised standards, it kept moving forward through the revisions. And to the extent that your employee goes out on exclusion pay, needs to, I believe it starts the day they have to start working from home. And then that clock starts.
Yeah, and exclusion pay would be required by employers if the employee is exposed to COVID-19 in the workplace. So that's when it would be required.
Okay, I'm gonna go to the next slide, but to the extent we get more questions, maybe we can circle back at the end, or like I said, I can follow up with you individually if we don't get to it during our webinar today. It's a lot to cover, I know. Yeah, as mentioned earlier, on December 13th, the California Department of Health issued guidance temporarily requiring masking on all indoor public settings, and that includes workplaces, irrespective of someone's vaccination status. And due to the increased confirmed cases of the Omicron variant on January 5th, that has been extended through February 15th. And as I mentioned earlier, you want to pay attention to the local health jurisdictions because they may have more protective rules than promulgated by the CDPH. For example, in Los Angeles County, among other changes by their local health officer, they are now imposing significant requirements on the employers with respect to face coverings. They'll have to, they're required to provide medical grade surgical masks, N95s, KN95s, but they also must ensure that the protective face mask is worn by all employers who are working indoors. We've received a question before, what if there's social distancing in the workplace? Do they have to wear a mask? Yes, you have to wear a mask indoors. Unless you're in the office by yourself and the door's closed, you'll operate with the philosophy that I need to be wearing a mask indoors, and I need to ensure that my employees understand that they need to wear a mask indoors. So this applies to both public and private employers alike. So if you have any questions about the masking mandate and any conflict that may arise between your local health jurisdiction, please reach out to us and we can help you through that assessment.
Right. So we also did have a question about whether KN95 or N95 masks are required yet. And so just to be clear that it's not yet required by the state, but local jurisdictions may require it. And there's no federal requirement either.
Correct. That's correct. So pay attention to your local health guidelines because sometimes they change just as rapidly as these ETS standards. So I'm going to pass it along to Angelica to discuss the federal guidelines.
Okay. So currently, the federal counterpart for OSHA has also issued its emergency temporary standards. They are currently in the comment period, so they have not taken place yet. Just generally, which employers are covered by the emergency temporary standards? So this would apply to employers, private employers with 100 or more employees, or since California has an OSHA approved state plan, it also would apply to public agencies, public employers with 100 or more employees. So because California, I mentioned earlier, because California is on this state plan, California would be required to adopt standards as strict as the federal OSHA standards, which are pretty consistent with what David just discussed. As part of these emergency temporary standards, there were federal vaccine mandates were also issued as to 4 categories or 4 groups. The first group, which probably affects the most employers, are private employers with 100 or more employees. And in California, as I mentioned, that would also apply to public agencies, healthcare workers, federal contractors and subcontractors, and federal employees. So last January 7th of this year, the Supreme Court heard oral arguments to determine whether two of these vaccine mandates were valid. So today, just a few minutes before this presentation began, the Supreme Court issued its decision. And as to the vaccine mandate for large employers, that mandate is currently stayed, which means that it is not going to go into effect until it makes its way through the appellate courts. But as to healthcare workers that receive Medicare and Medicaid reimbursements, that vaccine mandate was allowed to move forward. If we can go on to the next slide. Okay, so some employer takeaways are that the courts will decide ultimately the fate of the vaccine mandates. And as we mentioned, for 100 or more employers with 100 or more employees, that is currently that has currently been stayed by the Supreme Court. So we will be waiting for that to make its way through the appellate courts. You should also consider developing policies to gather vaccine information from your employees to get ahead, and then also consult legal counsel for any questions that you may have. And as I mentioned previously, in California, this would also apply to public employers with 100 or more employees. If we can go to the next slide. Okay, and I'm gonna, pass it over to Arlene.
Great, thanks, Angelica. So just to just to keep in mind, so this is going to be in the news for a little while about the Supreme Court stay of the this 100 or more mandate. California, as we know, has been much more protective of employees than many other states and even the federal government. So, there's nothing stopping from California from imposing its own mandates if it wanted to. So just keep in mind that things may be changing still in the coming months. But, even though the status of some of these federal employer vaccine mandates are in doubt, we do know a number of employers are still imposing vaccine mandates or vaccine and test mandates. Just this week, United Airlines CEO came out with a statement. United Airlines was the first airline to require its employees to be vaccinated. And he said that there are currently 3,000 employees who are positive for COVID right now, but not one of them is in the hospital. And he credited it to the vaccine mandate. He said before their mandate, they had on average one employee dying of COVID every day. And for the last 8 weeks, though, they've had this vaccine mandate and they've had no employees who died. So, so vaccine mandates do work and improve health outcomes for employees and their families. So now is the time to think about and I understand, I saw a statistic that 36% of American workers are working subjected to vaccine mandates. Now may be the time for you to consider, if you have these policies, whether you need to be changing the definition of what it means to be fully vaccinated. We're seeing this among different employers, and also colleges are now saying that to be fully vaccinated, you must have received the booster if you're booster eligible, because the science has shown that employees who are eligible for people who are eligible to be boosted, who are boosted, are also much less likely to be admitted to the hospital if they develop COVID. So that's something to keep in mind. We don't yet have any regulatory agencies who are requiring that, but I believe that it would be, just as you could have said fully vaccinated was 2 shots, now you can say it's 3 shots if they're eligible. And so if we can go to the next slide. We'll move back to Angelica.
Okay, so I'm just going to go ahead and discuss a few of the exemptions to the vaccine mandates. And if you are an organization that has a mandatory vaccination policy, you may already be familiar with these types of exemptions. So the 2 primary categories of exemptions fall under, the first being disabilities related to certain medical conditions, and the second would be sincerely held religious beliefs, practices, or observances. And these are protected under federal laws such as the Americans with Disabilities Act and Title VII of the Civil Rights Act, as well as a state law under the California Fair Employment and Housing Act. Because these are exemptions that are protected by law, it is unlawful for employers to retaliate against anyone for engaging in a protected activity, which would include requesting a reasonable accommodation to a vaccine mandate based on either a disability or a sincerely held religious belief. And if we can move on to the next slide. So we just want to make all employers aware that there should be written policies, or this should be included in your vaccination policy, these sort of carve-outs or exemptions to that vaccination requirement. Because this is a legally protected field, we do recommend that you train your personnel on how to navigate these types of issues, when an employee submits a request for a reasonable accommodation, and what questions are appropriate to ask or inappropriate to ask, and what duties the employer must engage in to make sure they're not running afoul of these legally protected classifications. And those 2 exemptions apply to both public and private employers. So we do recommend for public employers to also consult your MOUs. And we can go on to the next one. So another issue that we've been seeing a lot relates to counterfeit vaccination cards and employees falsifying vaccination status. As I'm sure you've all seen in the news with the NFL and Antonio Brown, this is an issue that has been coming up. Because of that, we do recommend that you train your managers and supervisors, or really anyone handling vaccination records, to train them to look for certain signs of counterfeiting. And this includes things like the absence of key information. If you've ever seen a vaccination card, usually it includes the manufacturer, the lot number, the date of the vaccine, and the location where the vaccine was received. And then also vaccination dates that are inconsistent with the CDC guidelines. So I'm sure, as you all are familiar with, it's recommended that there be at least a 3-week period between a first and second dose in a 2-dose series. So definitely look out for the right dates. Also, illegible government seals or cards that appear to be entirely printed with no handwritten information like the person's name. And then also uniformity of handwriting, because as we know, for a lot of the major vaccines, there are 2 doses for those series. So we just want to make everyone aware of that. If we can go on to the next one. Okay, so some takeaways for this is to check your policies to see whether, to ensure that, when employees are providing their vaccination records, that there is included there some sort of attestation where the employee certifies that the information that they're providing is accurate, and that, if it turns out that they're falsifying such information, that they could be subject to disciplinary action up to and including termination. So that just sort of reinforces the consequences for falsifying health records to ensure that employees are being truthful. And if we can go on to the next slide. Okay, so the next one is a new law, which is Senate Bill 606. And this law strengthens Cal OSHA's enforcement authority. So it does that by expanding Cal OSHA's enforcement powers by creating 2 new categories of violations and providing Cal OSHA with the authority to issue subpoenas during an investigation or seek injunctions restraining, the operations of your business. So these 2 new categories of violations include egregious violations and the fines for that, are enterprise-wide violations. And the civil penalties for this type of citation can run up to $124,000 for each willful violation. So we definitely recommend for all employers to ensure that their policies and procedures comply with Cal OSHA standards, and as well as reviewing, site-specific workplace safety hazards to avoid the issuance of these types of citations. And then also, because Cal OSHA now has this increased subpoena power, we also recommend that you communicate with Cal OSHA about any requests for information and cooperate with Cal OSHA to minimize the likeliness that they will seek injunctive relief. Because Cal OSHA has jurisdiction over almost every workplace in California, Cal OSHA applies to most public agencies. And if we can go on to the next slide. Okay, so the next category that we're going to talk about relates to the release of peace officer records, specifically as it relates to Senate Bill 16. And if we can go on to the next one. So what is Senate Bill 16? So essentially, in an effort to increase transparency in law enforcement, SB 16 significantly expands public access to police misconduct records and makes a few other notable changes, which we'll cover in the next few slides. So with respect to the personnel records of police officers, the general rule is that a peace officer's personnel records are confidential and not subject to disclosure. However, back in 2018, California enacted a new law, which has been in place since then, Senate Bill 1421, and that made certain exceptions to this general rule. So in effect, SB 1421 made 4 exceptions, and we'll refer to these exceptions as covered incidents. So under SB 1421, previously confidential peace officer personnel records are subject to disclosure under the California Public Records Act if they relate to an officer-involved shooting, use of force by a police officer that results in death or great bodily injury, and sustained findings of dishonesty or sexual assault by the police officer. So SB 16 expands this list of exceptions to that general rule, which makes the following records public if they result in sustained findings. So complaints of unreasonable or excessive force, a finding that an officer failed to intervene against another officer using unreasonable or excessive force, sustained findings of unlawful arrests and searches, and sustained findings involving prejudice or discrimination based on a legally protected class. So those are things like race, age, gender, sexual orientation. And if we can go on to the next slide. So there, SB 16 also includes some other additional requirements regarding the release of records, and that includes that records shall be provided at the earliest possible time and no later than 45 days from the date of the request for their disclosure, and that's pursuant to a Public Records Act request. It also requires that the release of records related to one of those covered incidents or one of those exceptions, that the disclosure occur even if an officer that resigns before the completion of an investigation. And then it also expands the record retention for complaints and reports or findings. Previously, it required that you retain the report or findings into police officer misconduct for at least 5 years. Now it is 5 years if the finding is not sustained, and or 15 years if the finding is sustained. So that means that it was found that they, on a more likely than not basis, that they engaged in misconduct. And if we can go on to the next one. Okay, and then so the last few parts of this is it also creates an employer duty to review the records. So under the existing requirements, law enforcement agencies must maintain the records of police officer records relating to misconduct by police officers. And then also that police officers seeking employment with another agency must provide permission to that agency so that they can view their personnel file. So the new requirement under SB 16 is that law enforcement agencies who are hiring a peace officer must request and review their file before hiring. And then it also creates another duty for police officers to report, to self-report the use of force. So that would require them to immediately report all uses of force to their employer. And if we can go on to the next one. So a few takeaways from SB 16 is to ensure that your policies and procedures for responding to PRA requests are in compliance with SB 16 and also include these expanded categories of accessible records. And then also, comply with all the requirements for requesting and reviewing peace officer personnel files, as well as understanding the permissible withholding timelines in SB 16 and any applicable exceptions to disclosure. We do recommend that you consult with counsel if you have any questions on this. And these amendments apply to public agencies that employ any peace officers. And if we can go on to the next one. Okay, I'm gonna pass this one over to David.
Thanks, Angelica. Next slide, please. So across the country, we've seen a lot of employers, both public and private, grapple with website accessibility. We've, on the private side, there's been a lot of work from home and a lot of people accessing their websites for the first time. And so you've seen a rise in ADA claims claiming that websites are not accessible due to lack of screen readers or anything for those with like low light visibility or closed captioning. And in the public arena, we've moved to a lot of public meetings where they're all virtual. So to the extent that your public meetings are held virtually, you also need to keep in mind these website accessibility standards. In California, the California Attorney General's office says, what does accessibility mean? So it means that you should be following the website content accessibility guidelines that are promulgated by the World Wide Web Consortium. We advise that you consult with an independent ADA consultant and have an ADA qualified user test your website for accessibility. You keep updated or modify your websites as necessary, or the use or access to your public meetings as necessary, including whether you're using closed captioning or screen reading for all constituents. And then you conduct routine website accessibility testing. So just evaluate your online platforms. Even if you have a mobile platform, make sure it's up to date and it follows those guidelines. Although we can't guarantee that someone won't sue, you rather be proactive in making sure your public meetings, your websites are accessible as possible to every member in your community.
We've helped a number of clients who've been receiving inquiries on this area, so we just wanted to make sure that you're aware. There are a number of people who are serial plaintiffs, like David mentioned, and bring a lot of these kind of claims. So it's just helpful to try to get ahead of it and make sure you are accessible in advance.
Thanks, Arlene. Next slide. And then I wanted to touch on SB 331, the Silence No More Act. This came out of the Senate Bill 820, the STAND Act, which was a direct outflow from the Me Too movement, which prohibited the use of confidentiality provisions in settlement agreements where the underlying claims were sex assault, sexual harassment, workplace harassment, or discrimination that was based on sex. What does SB 331 do? It expands that prohibition to any protected class under FEHA. It also prohibits employers from requiring their employees from signing non-disparagement agreements in exchange for raises or bonuses or as a condition of employment. So next slide. So what we encourage you all to do is update your form documents, your settlement agreements, your employee agreements, and to think carefully about resolving potential or ongoing litigation. Some of these prohibitions only trigger an active or pending litigation or arbitration charge. You want to make sure your agreements with employees upon receipt of bonuses or anything of continued employment or even separation from employment does not have a provision that has a non-disparagement clause or restricts the employee's ability to disclose information about unlawful acts in the workplace. Rather than a full analysis of what provisions you have to take out, sometimes it may be more cost effective or quicker for you to add language into your agreements that nothing in this agreement prohibits an employee from disclosing what they reasonably believe to be unlawful conduct in the workplace. Also in your separation agreements, you will be under the obligation to inform your employees that they have the right to consult an attorney, and you need to provide them 5 days in order to do so unless they provide a knowing waiver of that right. So just wanted to make sure you keep that in mind with COVID. Unfortunately, one of the big symptoms of COVID that there's a lot of people that have stopped working or have left work. And so if you do have separation agreements or non-disparagement agreements, we want to make sure that they're in compliance with the new law that went in effect on January 1st. Next slide. So I'm going to pass this over to Arlene. No, I'm sorry, to Angelica.
Oh, just one thing I did want to point out. We're not spending a lot of time this year talking about discrimination, sexual harassment, reasonable accommodations for disability. Those kind of claims and concerns are still happening all the time. That's kind of the bread and butter of what we see as employment attorneys, but there hasn't been as like a wholesale change or something that's particularly new. So just keep in mind that even though we're not spending any time talking about it today, you still want to make sure that there's no discrimination in the workplace and concerns are being addressed appropriately.
Thanks, Arlene and David. So the next category we're going to turn to is compensation in wage and hour. If we can go on to the next slide. So the first topic I'm going to discuss is the minimum wage increase. So as many of you may know, effective January 1st of this year, California increased its minimum wage to $14 an hour for small employers. So that means 25 or fewer employees, and then also to $15 per hour for large employers. So that means 26 or more employees. Employers should note that the minimum wage increases also affect the salaries of exempt employees due to the requirement that exempt employees earn no less than 2 times the state minimum wage. So in the case of small employers, that 2 times requirement would be a minimum salary of $58,240 per year. And for large employers, that would be $62,400. Finally, employers must also be aware of the local minimum wage increases imposed by your city or county. Employers are required to follow the stricter standard that provides the greatest benefit to their employees. So for example, the minimum wage in the city of San Jose has increased to $16.20 per hour. So employees in San Jose would have to be paid that minimum wage since it is the strictest standard. If we can go on to the next slide. So a few employer takeaways: update your minimum wage payments and postings to reflect these increases, and ensure that all of your exempt employees, so not just your non-exempt employees, but your exempt employees are being paid according to the minimum salary requirements. And those requirements are applicable to both private and public employers. And if we can go on to the next one. Assembly Bill 1003, it covers the expansion of criminal penalties for wage theft. So under the old law, an individual commits grand theft when they take the money, labor, or property of another in excess of $950. And grand theft is generally punishable as either a misdemeanor or a felony. So AB 1003 makes the intentional theft of wages, including gratuities, in an amount greater than $950 from any one employee, punishable as grand theft over a 12-month period. So this law authorizes wages, gratuities, benefits, and other compensation that are the subject of a prosecution under this law to be recovered as restitution. That bill became effective January 1st of this year. And for purposes of this law, independent contractors are also included within the meaning of employee. So entities that hire independent contractors should be aware of that. A few takeaways. Managers should be aware that they can now be held criminally liable for theft or wages, and employers should take affirmative steps to ensure wage and hour compliance to avoid these significant penalties imposed by AB 1003. And AB 1003 also applies to both public and private employers.
Yeah, I was just noting, as a practical matter, it probably isn't going to affect managers too much, but it's just good to be aware that, California is continuing to be concerned about wage theft.
We can go on to the next slide.
Oh, I think we had a question in regards to minimum wage. I think it says, is there a white collar minimum salary for employers of less than 25 for part-time employees? And if so, what are the minimum number of hours to be considered part-time?
So this is an area that has tripped up so many employers that I've worked with. While under federal law, there might be some kind of rules that might allow for something like this. In California, when you have the exempt salary, it doesn't matter if they're part-time or full-time. So a part-time employee who was exempt still needs to be paid.
Yeah, we can go back a slide. Yeah. A couple slides, actually. Yeah.
Right. So if the minimum exempt salary is $58,240, then even part-time employees would have to be paid that amount. So a lot of people get tripped up inadvertently on this one.
Thanks for the question. If we can go up to the leaves, benefits, and accommodations slide. Yeah. Okay. So the last category that I'm going to be discussing is leaves, benefits, and accommodations, specifically as to Senate Bill 95. So as you all may recall, Senate Bill 95 went into effect last year on March 29th with retroactive applicability to the beginning of the year. And that what that law did was expanded requirements for employers to provide supplemental paid sick leave to employees impacted by COVID-19. So that law expired on September 30th of 2021. However, we do want to note that the governor this past weekend called for new legislation to revive the supplemental paid sick leave policies as part of this, as part of California's coronavirus response package. We don't know, for sure whether this will pass or whether it will take, whether a different law will be enacted, but employers should consult with counsel to receive the most up-to-date information. If we can go on to the next one. And I'm going to turn this one back to Arlene.
Thank you, Angelica. So we have a few more minutes for questions if you still have some. I know that there have been some coming through the chat that we may not have gotten to. Feel free to put it in the Q&A and we can try to answer it. I think we did have one question, and I'm not sure that we can answer it quite clearly on this, about ADA and websites. What happens when you have, if your organization has a website, but it has a link to another website that's not compliant? Could you be held liable? I'm not sure if David, do you know that answer? We can help too. I think, well, part of the problem is the expense. If you are facing litigation, the expense of proving that may be more expensive than the expense of kind of paying the nuisance suit to try to just settle the case. Typically, a lot of the plaintiffs who are bringing these claims are just looking to get a quick settlement and then get out. So even if you have good arguments that you're not responsible, it may be more expensive to fight it than to pay a settlement. But I don't know, David, if you have other suggestions.
Yeah, I think the philosophy generally we can follow up is if you are hosting a website that is not compliant, you're at risk for those serial plaintiffs to say that your websites are not accessible and you're in violation of the ADA. But we can follow up as it pertains to whether one site is compliant and another site is not compliant. We would recommend that all the sites are compliant, but we can follow up on that. There was a question that came in the Q&A discussing during paid time. During paid time does not mean during normal working hours. However, it means that you need to pay the employee for the time it takes to take the test or travel to the test. So I hope that provides some clarification. It may be easier for you to quantify it by just sending the person out during the day. That way they're under their normal working wage hours, but they'll still be compensated at their regular rate of pay for the time that they have to take the test and travel to the test.
There was a question about exclusion pay and whether this is paid by the employer or Cal OSHA.
Oh, Cal OSHA definitely wants you all to pick up the tab. So this is all on the employer. And to the extent you have, if the employer provides leave pay for under the California paid sick leave law, that is not to be used to cover the exclusionary pay period. The exclusionary pay is for exclusions due to workplace COVID-19 exposures, and the ETS is explicit that the paid sick leave law should not be used to cover that.
I also just want to note that Cal OSHA has put out some FAQs where they try to break down a lot of these questions. So you may be able to find it on their webpage. And we've seen that sometimes where there's some confusion or conflict between different agencies, after a week or two, they're putting out more explanations and resolving some of the questions that may be a little bit unclear from their rules.
Should I answer some questions out of the chat? I'm scrolling through. I've seen quite a bit of questions in the chat.
I think, yeah, unfortunately, we have just about one minute left if you want to answer. Let's see. I think we're not going to have time to answer all the questions that we have in the chat. We are happy to try to follow up with you. As you can see, there's just a lot of things that are changing right now. So thank you so much for joining us, and we hope to see you soon.